contacted the father and told him that. With her finding out that, she got very upset, punches him and starts punching the girl in the face multiple times, Jana, with a closed fist. The son tried to break it up. She punches him in the face multiple times with a closed fist, and he falls on the ground and cuts his arm, Your Honor. The son calls a friend and tells him, I'm being assaulted by my mother. And so she calls 911, and then the police arrive. They observed on the female that she had bruises on her face, and it was swollen as well. But she's got quite a history on her. This is charged, as you can see, domestic violence second as well, because back on April 10th, 2008, she was found guilty or pled guilty to domestic violence at that time. But since that time, Your Honor, she has other convictions as well. She had on 4/10/02, she pled guilty to domestic violence, and she pled guilty to assault and battery. On 9/8/2009, she found guilty of assault and battery and retail fraud. On 8/10/21, she had retail fraud second. On 10/29/24, she had a domestic A and B that was dismissed. Very assaultive past, assaulting children. Child Protective Services has an investigation going on this person. To punch your children in the face multiple times over the fact that they talked to the father because they didn't get their medicine. I believe a cash bond is necessary in this case, Your Honor. Absolutely no contact. And she's able to post the $20,000 10% bond. There'd be a tether with house arrest at a different location. Thank you.
Your Honor, that's incorrect. I don't have a CPS case against me.
Stop. Can you hear me when I say stop?
Okay, it's a little loud.
Stop. And I'm saying stop. So I'm going to tell you to stop, because though you have the right to speak, anything that you say can be used against you in this case. I'm going to let your attorney speak for one moment as to this issue. Counsel Scheid.
Thank you, Your Honor. That's correct, ma'am. Anything you say right now can and will be used against you. That's why the court is trying to stop you from saying anything, although you do have a right to speak. We don't want anything to be used against you, okay? It's all part of the record, so I'm gonna advise you to not say anything. I will answer these questions, make an argument on your behalf, and then if there's anything you still wanna say, it is your right to speak, but as your attorney, I'd advise you not to. Your Honor,
okay. So, do you understand what your attorney has told you, ma'am?
I do.
Okay, now let me ask Counsel Ragnan. Okay, yes. Do you have any new or any information as to whether or not the complaints are still at that location on Vicksburg or not?
Well, I don't have that information, Your Honor. I believe it just happened, but I'm not sure if they're there or not. But if they are there, we'd like them to stay. If not, then she could go back to her residence if she makes bond. But I certainly think that the children should be able to come and go as they please there. They have their school books, they have their clothing there. I don't think they moved out to some other location. I mean, they are in high school, I believe, and they should be able to come and go into their house and not be disrupted in their routine by this mother. Thank you.
Okay. Counsel Scheid.
yes,
go ahead.
So she's not on probation or parole or anything pending. I know that the people indicated that there's a CPS case. My client indicates that there isn't a CPS case. Unfortunately, at this time, I couldn't verify if there was or there wasn't, Your Honor. She is a college grad. She's a lifelong resident of Michigan. The complaining witnesses are her children, ages 15 and 16. So they all live together. I don't know who they will be staying with, if not their mom. There are, I mean, 15-year-old's a minor and the 16-year-old. I would be asking the court to consider a personal bond and no assaultive contact. Now, if the court is not inclined to do that, then I ask the court to give a personal bond and no contact. I I don't know how they're gonna arrange that with the kids, Your Honor. I don't know if there's a CPS case. I don't know if the kids were taken somewhere else at this time. But my client understands that she has to follow all court orders. It is charged as a misdemeanor. They are allegations. She is presumed innocent unless proven guilty beyond reasonable doubt. I don't believe she has anything assaultive on her record. I believe Ms. Ragland said one was dismissed, if I heard correctly. So I'm respectfully asking the court to consider a personal bond here. I would ask for no assaultive contact, but if the court is not comfortable with that, then my client understands.
One, the court is gonna keep the no contact with the minors. Okay. Two, no firearms or dangerous weapons. Three, this court hasn't heard anything to indicate that the children are not there. So at this point, Ms. Harding, you're not to go back to that residence until this court has independent confirmation that the children are not there. Do you understand that, ma'am?
Okay, Your Honor, they.
Okay. So,
I need to speak to
ma'am,
my attorney.
no, hold on,
Okay.
ma'am, hold on. So let me say this. Whoever your attorney is, if they
Uh-huh.
find out that the children are not there, they can
Okay.
approach the court and they can address that issue as to about the residents, about you going back to the
Okay.
residents. Do you understand that?
Okay, that's fine. That's why I said I need to speak with my
Okay,
attorney.
so now the other thing is that, Counsel Ragnan, you did say that, did she have some prior convictions
Yes.
of
Your Honor,
assaultive
she does.
behavior?
That's.
Is that more than 10 years ago?
She has, let me go back here a second, if I may.
Or does she have any convictions in the last 10 years of assaultive behavior?
Well, she is a second, as you can see, because she has a previous domestic violence, but that was.
Yeah,
as you
that's from
said,
2008. It's more than
Correct.
10 years ago.
She also has a AMB from 2009. She has retail fraud second from 2021. So I don't believe she does. She had an AMB on 10/29/24 that was dismissed by the party.
Okay.
That was charged.
We're just looking to see whether or not she has convictions. So she doesn't have any in the last 10 years. Okay. Counsel Scheib, she needs a police escort one time.
Yes, Your Honor.
Okay. All right, Ms. Harding, you're going to get a one-time opportunity to go with the police to get some of your belongings. Do you understand that?
Okay, Your Honor.
Okay. And with that being said, okay, I'm gonna give her a $50,000 personal bond. That means, Ms. Harding, nobody has to pay any money for you to get out of jail. I will say, and I will tell you right now, is that if you violate the bond conditions, you go there without the police, you have contact with the kids when you're not supposed to, you go to the residence and you stay there when you know you're not supposed to be there, okay? Those can be considered all bond violations, bond condition violations, and then next time you could be looking at a monetary bond. Do you understand that?
I do.
I'm gonna give you one chance, $50,000 personal bond. I'm not gonna place you on a tether. I'm not gonna give you a monetary bond, but one-time opportunity. Do you understand that?
I do.
Okay. That concludes
Okay,
your
Your
argument,
Honor.
ma'am.
Okay, I need
You
to
have a
speak with
question?
my attorney. Yes, I do, Your Honor. I need to speak with my attorney, straight after this so that we can, verify with the
Okay.
kid situation in my home, my residence.
Counsel Scheib, can you get defense counsel after we arraign the other individual so she can be?
Yes, Your Honor, and I just have a question for the court. What type of independent information would the court need to get other than what my client is?
Other than what, other than your client say so. So if they check and they find out, or they have a CPS, Child Protective Services indicating that the kids are no longer there, or anything like that, or they're in the custody of another family member, a third party, as long as it indicates that the children are not there.
Okay,
And then
thank you.
that matter can be removed and can be addressed with Judge Garrett. Thank you. Okay. Thank you, ma'am. I'm gonna have you stand by
Come, get up, get up.
Okay, Your Honor, okay.
You're gonna sit right there.
Thank you, Your Honor.
Mr.
Thank you.
Mr.
Thank you,
you.
Magistrate Burton. Have a nice evening.
And we still have another female, and we still have to do Mr. Graham.
Okay, I better wait then. Thank you.
Yes.
You got to see.
Sorry about that.
Ma'am, would you state your name, please?
Jay Stevens.
This is case number SP 145-75932 OT. City of Detroit versus J. Donella Stevens. Ms. Stevens, you have a misdemeanor matter for failure to display. That carries up to 93 days in jail. There's a pretrial that is scheduled for February 20th, 2025 at 8:30 before Judge Archer.
What
And
is that? What
I'm
is
sorry, I
that?
didn't hear. That will
What
be
did
your
you say?
pre-trial. That's your next court date, February the 20th. And you're gonna receive a personal bond in this matter, okay?
Okay.
Okay, all right. Ms. Stevens, ma'am, you also have a right to remain silent. Anything you say orally or writing can be used against you in a court of law. You also- I repeat that. You have right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. You have right to remain silent. Anything you say orally or writing, it can be used against you in a court of law. Understand those rights, Ms. Stevens?
Yes.
Okay, thank you.
Okay, and as it relates to the felony matter, calling case number 24-0610-2301 FY, people of the state of Michigan versus J. Donella Stevens, also known as Jade, Jade Stevens. Appearances, please.
I don't know if it's JAYD.
Right, I just gave an alias. There's another way that your name was spelled now. Appearances, please, for the people.
Lisa Coyle, appearing on behalf of the people.
Justin Shaz on behalf of the U.S. Reading and Central Constitutional Circumstances.
Court will enter not guilty plea on behalf of Ms. Stevens. Ms. Stevens, you have two court dates, ma'am. You already have the date that's been set for your pretrial on your misdemeanor. The next court date you have for your felony, that will be January the 30th. That's a probable cause conference at 8:30 before Judge Giles. You also have a preliminary examination that's scheduled for February the 6th, 2025 at 8:30 before Judge Giles. The date of 1:30 will be by Zoom. The date of February 6th will be in person. Ma'am, you understand those court dates?
Yes.
Okay, as it relates to bond,
Your Honor, this is non-assaultive. There is no KPS history on this case. No objection to a $25,000 personal bond in this matter. Thank you.
what's your position, Ms. Scheid? The court will set bond at $25,000 personal. Okay, ma'am. Ms. Stevens, we're all done.
Thank you.
Step aside. Thank you. Anything further from either the people or the defense?
No, Your Honor.
Thank you.
EDC.
Go sit down over here, ma'am. Thank you.
Yes, ma'am.
Can you put, Miss, I believe it's Miss Harding, I believe it was.
Put her back, bring her back.
She wanted to speak to an attorney
Yes,
in
ma'am.
front of the camera, and I'll have another defense counsel. Ms. Harding, you wanted to speak to your defense counsel, correct?
I did, Your Honor.
Okay, and it's still that position? You still want to talk to a defense counsel, correct?
Correct. I wanted to, go ahead and confirm, with the residents.
Hold on,
So that way.
okay, I'm gonna let you, ma'am, I'm gonna let you speak to the defense counsel. As long as you have some
Okay.
questions, we just need an attorney to log in, and then, I'll put you in breakout room.
Okay, so that way she can get back with you to confirm that.
Yeah. So
Okay.
just stand by.
All right, I'm gonna close this door, okay? I'll be back.
Okay, thank you, Your Honor.
Thank you. Council Reagan's gonna,
If you there, you can call in there.
if I keep her,
No, just hang up on.
oh, okay. All right, then I will.
Yes, sir. Would you state your name for the record, please?
John Anderson Graham.
Oh, calling case number 25-0550-5401 FH. People of the state of Michigan versus John Jon Axton Axton Graham, also known as John Axton Graham, John, and then John Graham. So there was a capias that was issued on January 21st, 2025, because you failed to appear for a preliminary examination. That was before.
You're
And
on,
then
No comment.
what we said.
excuse me.
Okay, we'll let your attorney speak, but right now, because this is a capias, we're gonna check with the clerk to find out whether or not they were able to reach Judge Jefferson.
Miss Lisa?
Okay,
Magistrate Burton?
yes,
Samuel A. Ragland for the people, we will not be appearing on this matter because of the felony capias. Thank you.
thank you.
Okay, so just let me know for the record that Judge Jefferson is not available and go to do the rest of the arraignment. You can't do anything about that. That's the whole thing. Yeah, you already know.
Okay. Judge Jefferson is not available, Ms. Shive, and so we're not able to,
So let her go, put her name on the record. I just said if you're beginning.
Ms. Shive, I'm sorry.
I know there's a capias, so we handle these a little different. So
Okay,
Jessica Shab, on behalf of Mr. Graham, who waives formal reading, understands his constitutional rights and stands here.
Intricate,
we'll enter a not guilty plea on behalf of Mr. Graham. Mr. Graham, you have two court dates. Your probable cause conference is scheduled for January the 29th, 2025 at 8:30. You also have a preliminary examination that is scheduled for February 5th at 8:30. Those will both be before Judge Jefferson.
Okay.
And as it relates to your bond condition, you are not to use or possess any illegal controlled substances.
Okay, and then as of this right here, I have to cite it. As of January what?
As of January 21st, 2025,
Warrant was issued.
a warrant was issued in the amount of $2,000, 10%, because you failed to appear for the preliminary examination. And we have no authority, I have no authority to change that bond, sir, so your bond will remain at $2,000, 10%.
Okay.
Is that affordable or unaffordable, Ms. Shine?
That is unaffordable.
Okay.
Okay, you have a bond redetermination on Friday, January the 24th at 2025 at 9 o'clock before Judge McConicle or Judge Williams.
That's it.
Okay. Thank you.
Okay. Okay, thank you. Thank you, Ms. Shine.
Thank you, DDC.
Thank you, DDC.
All right, thanks everybody.
Thanks for your patience today. Thanks for your
Stop
Thank
it.
you, Your
You
Honors.
did great, Magistrate Burton. Magistrate Arcade Turtle, good to see you.
Thank you, Your Honors. Thank you, DDC. Thank you, everybody.
I just want to make sure the date for Mr. Graham Hill, it was 124.